Viewers, welcome back to the Personal Injury Law Show. Before the break, we're talking about this case of Tavesky. Sarah, what are some of the interesting pointers that come out of this case?
The one really important factor that I found interesting that came out of the court decision was that the court held that because he was disabled despite taking the voluntary redundancy, that the two aren't mutually exclusive. So just because you take a voluntary redundancy does not mean that you actually aren't disabled when you take that redundancy. So they can still consider a claim for TPD benefits if they've taken that package, because they're still not able to do.
I still think it's problematic, Nunz, if someone takes a redundancy, in this case it was 120,000, if there's no reference in the documentation to taking it because you've got ill health, I think you'd have problems trying to get one of these claims accepted.
Look, you could, and that's why I think it comes down to the facts like this case did, and that's why I think it's important on the employees and whichever superannuation policy that they engage to make sure that those forms, I suppose, spell out exactly, I suppose, all those circumstances and potential events.
Sarah, eventually, after 3 applications and the matter going to court, his claim was accepted, wasn't it?
Yes, it was, Tony. The court in this case actually supplemented their own decision for that of the trustee. They determined that the trustee, after 3 rejections, was not in a position to execute its fiduciary duties, so they made their own determination. They decided to execute the trust themselves, which means that they sent both parties away and asked them to get evidence, in this case medical evidence, that showed that at the time he ceased work back in 1998, that period, at that time, evidence that showed that he was not able to return to work. Subsequent to evidence that was submitted by the plaintiff to the trustee for the proceedings, meant that the trustee then determined to go before the court and say, on the basis of this evidence, we will accept the client's claim.
Nunz, one of the things I found in this case that was a bit interesting was that in 2006, which was sometime after his first application, he submitted all these witnesses to talk about how he was coping at work.
Yep.
Why didn't he do it earlier?
Look, that begs an interesting question. I'm not sure why, but I suppose it's important to know from, I suppose, a viewer's perspective is that the discovery process is always ongoing. So it doesn't matter how many applications you try or rejections you have, you can keep submitting.
And actually the court said that.
You can keep submitting information. So you can have 10 attempts at this, but the reality is that you need to provide them with enough information to convince them otherwise.
I'll tell you what, the trustees of the fund were pretty keen to make sure he didn't get his money.
Absolutely.
And in fact, there was a little snippet I want to take you to of a surveillance person who was taking video at the time, and whilst he's taking the video, he was making commentary. And I'll just take a little bit of this where he says, "Come on, Wog, move that big rock there or something. Come on, mate, I'm losing another effing tape. F off inside, mate. My arm's getting pretty effing sore, you know. When you going to get up? I want to have a drink, wait there and sit up, freak." I mean, that's outrageous. And the court commented about that.
The judge was appalled by that behaviour, and I think it didn't help in them coming to a finding. So.
Wouldn't you think they'd erase the audio in something like that, Sarah?
You would think so, Tony. I think that it just shows that in this case, while the court held that the trustee was able to have surveillance undertaken on the plaintiff, that in this case it wasn't going to affect the way that the plaintiff was seen because he did have that injury.
The only thing that concerned me about this case, and this is where applicants have got to be careful, mind you, the plaintiff got 350,000, so it was a pretty significant claim, plus interest.
Yep.
What you've got to be careful of is the surveillance, because in this particular case, what was he doing?
Well, he was doing gardening and things around the house. I think it was a chainsaw or a hammer at some stage. So, look,
for 4 hours.
Look, it didn't look good on video, but I think that's just 2 lessons that arises out of this case. Is that one, be careful. Superannuation policies will enforce surveillance on you, so they'll check to see what activities you are doing. And 2, in terms of whether there is surveillance, they're obliged to give it to the plaintiff for them to respond to it. And that's what the court found, that the plaintiff didn't have an opportunity to respond to the surveillance. And ultimately that was a reason why the judge set the decision aside.
The law has been evolving, Sarah, to the benefit of applicants these days?
It has been, Tony, generally. There's a few areas now where there's still some difficulty and it's still vague in terms of which way the court will go. There's conflicting opinions. In this case, one of the really important things that came out of it was that the funds and their insurers are required to give the plaintiff an opportunity to actually respond to any information that can be construed against them, whether or not it be surveillance or a bad medical report that says it's not supportive of their claim. In which case then they then have the opportunity to either address that or seek further medical opinion as to the contents of that report.
Sarah, it's a pity WorkSafe don't have the same attitude and the courts don't enforce that upon them. Let's get on to the next case of Magdalene Mott and Commonwealth Bank Officer Superannuation Corporation. Let's see, give us the facts.
Well, basically, this is a case in which this particular plaintiff was a bank teller, had an injury over the course of his employment and went from full-time to part-time work. Now, the issue with this is that just before he put his claim for TPD, or total permanent disablement, in, this particular company changed their policy of insurance. So they went from what's called Hanover Insurance to ComInsure. And the Commonwealth Bank say that basically the policies were the same in terms of its entitlement, but this plaintiff took a different opinion on that.
So what happened?
The plaintiff, when he lodged his claim, it was rejected on the basis that he didn't fulfil the ComInsure policy, sought to make application to the court for a determination that the policy was not the trustee had not acted in favour and in support of their members by changing the policy to one which was not as supportive and was a slightly harder, in his words, definition to satisfy.
But it wasn't an issue about premiums? Wasn't that the reason why the policies were changed?
Well, the trustee initially looked into the premiums offered by Hanover, which were going to have a markup of 130% for premiums. At that time, they put a tender out to ComInsure to make an offer as to what premiums they would charge, and they were told that they would only charge 80% markup, and they would not mark those up again for the next 3 years.
Fixed for 3 years, yeah.
So that ultimately is passed on to the fund members.
Did he win his case?
Look, he didn't, but the big, I suppose, change in the policies from the plaintiff's perspective was that they defined, or ComInsure defined occupation as either full-time or part-time work. And he was working part-time, so he definitely satisfied that policy. And the Hanover policy defined occupation as just full-time work. So he thought, well, I'm a chance to get that. And that's, look, ultimately he didn't succeed anyway.
What else came out of this case, Sarah? What's your take on it?
The interesting thing was whether or not the trustee had discharged its duties in looking after the members of the fund. Apart from the fact that they did save them quite a lot on premiums, they also did seek legal advice as to whether or not the two policy definitions were identical enough to not be detrimental to the members.
So would you say it was unlucky?
I don't think so in this case. I think he would have had difficulty discharging the total and permanent disability policy in any event because he showed an ongoing capacity for work.
Okay.
But they sought the advice of a big commercial law firm in Freehills, as you know, Tony.
And they generally make a few mistakes too.
Well, they can, but in this case they thought that there was no detrimental effect on its members, and that was found.
We've got to go to a sponsors break, and after the break we've got the mailbag. Thanks for coming on board, Nons.
Thank you. Thanks, guys. Thanks, viewers.